Hello, I'm Mark McSweeney, Executive Director of the Association Societies Alliance. We are proud to partner with our member SAEs across the country, and of course, Jeff Tenenbaum, Nicole Miller, and Adam Walsh to provide today's program, Office Lease Challenges During and After the Pandemic, Tips, Strategies, and Pitfalls for Associations. Today's webinar is being recorded, and a link to the recording will be made available after the program concludes. Please note that there's no slide deck for today's program. During the program, we will have an opportunity for Q&A. To ask a question, please enter that into the question box on your screen, and we'll be sure to ask the panel to address those on your behalf. Before we get started, I wanted to quickly take advantage of this opportunity to remind you of our new real-time compensation benchmarking program, a 24/7, 365-day-a-year platform available through your local SAE that provides association executives with compensation and HR-related data, offering key benchmarking information for your important staffing decisions throughout the year. Check with your local Society of Association Executives to learn more and start participating today. And new this year, the survey is collecting data on association DE&I initiatives. As a special thank you for those who participate in the survey by April 30th, yes, we've extended the deadline out to the end of this month, participants will receive a free DE&I snapshot report based on the data received. And with that, let's get on to the reason that you're here and introduce today's moderator. Jeff Tenenbaum is one of the nation's leading nonprofit attorneys, and also is an accomplished author, lecturer, and commentator on nonprofit legal matters. As managing partner of the nationally recognized Washington, D.C.-based Tenenbaum Law Group, Jeff counsels his clients on the broad array of legal issues affecting trade and professional associations, charities, and other nonprofits. For 19 years, Jeff practiced law at the Venable Law Firm and chaired its nonprofit practice for most of that time. Among numerous other honors and awards, Jeff was the 2006 recipient of the American Bar Association's Outstanding Nonprofit Lawyer of the Year Award, and is only one of 5 lawyers in the prestigious U.S. Legal 500's Not-for-Profit Hall of Fame. Jeff is the author of the ASAE published book, Association Tax Compliance Guide, and currently serves as chair of the American Bar Association's Trade and Professional Association Subcommittee and on the ISAE Legal Advisory Council and Public Policy Committee. With that, I'm going to turn it over to Jeff.
Thanks, Mark, and good afternoon, everyone. Good morning to those of you in the West Coast. Welcome to our program today entitled Office Lease Challenges During and After the Pandemic, Tips, Strategies, and Pitfalls for Associations. As many of you know, I've spoken to and with many of you over the course of the last 12 months during this pandemic about a variety of legal challenges that have affected associations during this time. One of the legal challenges that associations have been grappling with during the pandemic, and certainly are grappling with now, looking hopefully past the end of the pandemic, hopefully sooner rather than later, are their office leases. It's something that my colleague and I hear about all the time from our clients, and something that I know is very much top of mind for so many associations, with so many associations having faced the need to work virtually over the last year, but now recognizing how effectively so many of them can function. Some associations, certainly not all, but some associations are looking to potentially reduce their office footprint in terms of the amount of space that they have. Some associations have decided to go all virtual. Some are looking for more of a hybrid model between in office and virtual work. All of this has significant implications for associations' office leases. And generally, there is no silver bullet solution for an association that wants to make a change under an existing lease that's not ready to expire from a larger footprint to a smaller or no footprint. So that is what gave rise to today's program. I am not a real estate lawyer. I am certainly not a real estate broker, but you have a top-notch real estate broker and real estate attorney on the panel here today, in Nicole Miller and Adam Walsh, 2 individuals who I've had the privilege of working with and now get the privilege to speak with on today's program. So let me give them their proper introductions, and then we'll dive into the program. First off, Nicole Miller. For nearly 2 decades, Nicole, a tenant broker and senior managing director at Savills, based in Washington, D.C., has been representing office tenants globally with their real estate and office needs. She works exclusively with tenants who are looking to lease office space renew, expand, restructure, relocate, or sublease, and/or purchase, sell, or capitalize on build-to-suit opportunities. Nicole specializes in solving the real estate needs of associations, nonprofits, as well as law firm, corporate users, and tech firms through office space identification and evaluation, lease and overall business negotiations, along with portfolio optimization. She's executed more than 3 million square feet of record-breaking lease transactions for some prestigious clients, including the American Hospital Association, the American Alliance of Museums, Hogan Lovells, Evershed Sutherland, the Bizzuto Group, and Kimley Horn. Nicole is an award-winning real estate broker, and she frequently speaks on a variety of real estate topics from the office tenant's perspective, given her exclusive representation of tenants. Adam Walsh is a real estate partner in the law firm of Grossberg, Yokelson, Fox, and Beta, based in Washington, D.C. He has 20 years of experience working with both institutional and entrepreneurial clients in the acquisition, development, structuring, leasing, and financing of commercial real estate projects. Complex transactions that Adam handles include joint venture formations, construction, mezzanine, and permanent loans, ground leases, recapitalizations, and sale leasebacks. He also advises pension funds, real estate advisory groups, real estate investment trusts, and commercial and residential developers. These projects include office buildings, new and converted residential condominiums, assisted living and other senior housing and medical facilities, regional and strip shopping centers, and retail and mixed-use developments. He has spearheaded legal teams in closing large multi-state and multi-property acquisitions and dispositions, and has managed commercial finance transactions in nearly all 50 states. Adam represents institutional and entrepreneurial landlords in leasing office, retail, and industrial flex space. So it is very clear you have two bona fide experts in the space, and I'm very fortunate to have them as our panelists. We're all fortunate to have them as our panelists here today. The way this is going to work is I am going to ask questions to both Nicole and Adam, but we want this to be a very interactive discussion. I told both of them to feel free after I ask one of them, the other, if you have something to add, to chime in, offer a different perspective, a corollary, an example, a war story, etc. And we want you guys, the audience, to do the same. Feel free to please pose questions in the question box throughout. I will be monitoring those and posting those to our speakers as we go along. So with that, let me give our first question to Nicole. Nicole, what lease provisions are you seeing to be the most important to have given COVID and ultimately moving forward post-COVID?
Well, thanks, Jeff. And starting out with a big question, and certainly an important one there. There's so much to be touched upon, but kind of big picture, some of the really key provisions that we're seeing, whether you have it in your lease currently or you want to get it in your lease moving forward, really, really good sublease provisions, and I can get into a little bit more of what that looks like. Termination options, if at all possible, as well as contraction and expansion options. The name of the game here is flexibility. So you want to have as much leverage, as much opportunity along the way to be able to use those levers depending on what you're looking to do as an organization, whether you want to grow, shrink, move things around, you want to have that flexibility. In terms of subleasing, and I know Adam can chime in here in a moment, some of the things that we're seeing that we really don't want to have in leases is when a landlord says that as a tenant, you cannot sublease to other tenants in the building or the complex, which really puts associations and nonprofits and tenants in general at a real disadvantage because that's such a good pool of opportunity in terms of subtenants. The other one that's a real gotcha or can be is when the landlord says that as a tenant, you cannot sublease to anyone that they're talking to or could be a prospect for them for the building. And so that creates a lot of complications, as you can appreciate and imagine, when they're looking at your space and trying to look at direct space in the building. And so that can be a real complicating factor as well. And then for terminations, the key and what we've really pushed for is to make sure the termination is clear. And if there is a fee attached to it, to have that calculated out and spelled out in the lease, as opposed to some really long, convoluted calculation that then when you pull out the lease years later, everyone's trying to pull out their calculators and come to an agreement as to what that description is. And then, the last thing I would say is overall pandemic protection. And can you get delayed rent? Can you get delayed start dates? What does that look like in protecting tenants moving forward if and when something were to happen like this again?
All right, Nicole, one clarification question, one follow-up. So when you say termination, you're talking about a provision that would allow the tenant to terminate midterm during the lease term before it expires, and then spelling out what the consequence of that would be financially, what sort of cancellation or termination penalty would be assessed. Is that right?
That's exactly right. And those typically come, I'd say, mid to 3/4 of the way through the lease. And it's a negotiation in terms of what that looks like and what the possible calculation, if there is one, what that looks like. And it's certainly something that is good to have in terms of flexibility.
Okay, so all of these things are kind of a, if we had a crystal ball, a year and a half ago, or pick your, your date pre-COVID, these would be the kind of things you would want to have in your lease to be able to give you more flexibility in this time of the pandemic and post-pandemic, when a lot of associations are looking to reduce their office footprint. But let's say they didn't work with you as their broker, and they didn't have all of these things in their lease, yet they are facing a situation where they have so many staff that aren't ready to go back to the office. Maybe some that want to continue to work virtually completely. Maybe some that want to have a hybrid model, so they only need half as much space. In a situation where your lease doesn't have all of these flexible provisions, and if they were to terminate, they would basically be stuck with paying the rest of the rent that's due on the lease, which would be kind of the default termination provision, which would cripple a lot of associations. Give us some ideas for some creative options that you're seeing, things that you've been utilizing to help some of your tenant clients as you work through these challenges.
So great question. And what we do first and foremost is we sit down and we understand the lease. So what is in the lease? What can and can't the organization do based on the terms? And then let's hear from the organization and understand what the drivers are, what they're trying to achieve. We then marry that up with what's going on with the landlord. Are there other expirations coming up? What is their loan maturity date? What are the other drivers that the landlord has? And then marrying those two together to try to figure out the best plan for the tenant moving forward. And so to your point about, what can a tenant do if they're in their lease, they don't have these levers or can't use these levers, what's one to do? Certainly as we advocate, there's a lot that can still be negotiated. And does that mean a restructure? Could we somehow figure out how to restructure the lease to lower the rent? Is it a rent issue where they really need some rent relief? Can they get free rent? Certainly a negotiation that we would have on behalf of the tenant and see what that looks like, and what, could we extend the term for a little bit to get some of that up front and provide some relief there? Is it that the tenant wants to rearrange the space and needs money for furniture, or needs money to reconfigure or change up the space to make it more COVID friendly? In that case, going to the landlord, getting from them a tenant improvement package, money from the landlord, using the landlord's money to update the space. So there's certainly a lot to be done. It's a matter of figuring out what the pain points and what the focus is, and then figuring out from there what that looks like. It also could mean a move situation where if they have just a few years left on the lease, we're seeing in varying markets where you could move into another space, say 2 years, 3 years in advance, rent-free, and leave your prior space behind. So there's also that type of solution as well.
Thank you. Those are helpful suggestions. I'm going to ask a question to Adam, but then Nicole, feel free to chime in as well. So we all been reading about how hot the residential housing market is right now in most parts of the country, and how it's just on fire, and likely going to continue that way for a while. And I know it's very hard to generalize. We have a nationwide audience here, even though 3 of us are based in DC. We have folks nationwide, but generally speaking, how would you describe the state of the kind of commercial real estate market, particularly in the urban centers throughout the country, compared, maybe compare and contrast to the residential housing market? And what I'm getting at is, how can that be potentially utilized as leverage for the association in these various negotiations? Adam?
That's a good question. So the worst sector right now is hospitality. The second worst sector is probably retail. And then the third worst is office. And then the healthy sectors right now are industrial, logistics, and residential. So as you said, every market is different, but generally speaking, this is a very weak commercial office market for landlords. And frankly, it was pre-COVID as well. What that means is it's a very pro-tenant market if you are in a position to be negotiating a new transaction. If you are coming to the market for space right now in Washington, D.C., Nicole would be very successful in negotiating a very attractive concession package for you in terms of rent abatement and allowance and other things. The office market was really kind of overbuilt even pre-COVID. There's a lot of sublease space on the market. Vacancy rates have been high, and obviously COVID has only exacerbated that. So what does that mean? Well, it means you have a lot of leverage if you're in a position to transact. If you're a tenant in the market looking to lease space, or if you've got a renewal coming up. The flip side of that, though, is because it's a soft market, what does that mean for the landlord if you're in the middle of your lease and you're looking for some relief? Nicole did an excellent job putting it in context. For the landlord, it's really going to be about the deal they may be able to offer you. It's going to be just as much about your finances as it is about the health of the individual office building that you're in. What's the vacancy rate in that building? How long has the landlord owned it? Are they looking to dispose of it? Or they refinanced it recently? So it kind of depends. Where you stand depends where you sit, right? If you're looking to do a new deal, you're going to get a very attractive package from a landlord. But on the other hand, if you're not, and you've got to resort to some of the negotiations that Nicole was alluding to, the soft market might kind of hurt you. I mean, the landlord knows that if you were going to look to, quote, get out of your lease, there's nobody behind you to lease that space. So landlords are not interested in in buyouts, so to speak, where you say, all right, let me out a few years early, maybe I'll give you an upfront payment. Those have been harder to come by. What landlords have been willing to negotiate pretty readily when COVID hit for office was if you could establish through being very transparent with respect to your financial situation, how COVID has impacted you in terms of whatever your funding source is, that if you were willing to not necessarily have your rent abated, but to get your rent deferred, where you would have June, July, August, September, no base rent, maybe you'd still pay your expense share. But then what the quid pro quo for that would be, you would tack on those months at the end of the term. So if you've got 5 years left in your term, you're like, we're not gonna have any revenue for the next 6 months. We cannot cover the rent, Mr. Landlord. Give me these next 6 months, no rent, but I realize I'm gonna have to pay that back to you. Maybe I'll pay those 6 months back to you when the pandemic's over a 12 or 24-month period, or maybe we'll extend the term on the back end and rework it that way. So there are a variety of circumstances, but the overall fundamental, to get back to the premise of your question, it's a soft office market, or it's a pro-tenant market.
Right. Those are great suggestions. Really, these are all really good practical suggestions, some of which I had not even thought about myself. So if you're an association that's, say, in the middle of a lease and it really just wants to get out of the lease altogether because it's facing some real financial difficulties and it's decided it really wants to go to an all virtual workforce, you gave some suggestions. I want to ask you about another suggestion that I've seen some of my clients toying with, and that is if they are facing, you talked about being transparent about their financial hardships, and if they're even facing the prospect of bankruptcy or something similar, have you seen, or would have you seen success stories in using the threat of not being able to pay out the full amount of the balance of the lease as some leverage to extract concessions? You just gave a great suggestion about maybe getting some short-term rent abatement in exchange for extending the lease. But what about kind of using the threat of default to extract some significant concessions?
Yes, I have seen that. In fact, I'm representing a landlord, not a tenant, on a building over in Northern Virginia now, where the tenant did just that. They actually went as far as to hire a bankruptcy counsel to make that presentation of how that was a real threat. I mean, it's interesting with a nonprofit, right? You don't usually have a guarantor, a personal guarantor with an association or a nonprofit lease. That's a good thing. So there's often not a real true warm body for the landlord to look for. So you've got your security deposit, and then you've got the credit worthiness of tenants. So if you can convince the landlord that there's no there's no one to go after, right? If we throw you the keys back lawsuit is relatively worthless, and what you really want is the space. Landlords, and an example I gave you that where the tenant really threatened bankruptcy, they just restruck a deal. The tenant basically agreed to pay a chunk of the arrearage and repay the rest of it over time, and then they extended the term. So yeah, there's no reason to be bashful. You can certainly and be candid if that's the reality of the financial situation. I mean, when the pandemic first hit, landlords were overwhelmed with the retail tenants. Like, no one had even any time for office because every retailer immediately stopped paying rent, and some of them were permitted to stop paying rent based on municipal ordinance and emergency legislation. But there was no one going into these stores. There was no one to pay rent. So the immediate triage was retail, and they were like, office, sit tight for a little while. And then there were a fair amount of these renegotiations. But to be perfectly frank, landlords are probably a little less sympathetic on April 8th, 2021 on restructuring for office than they were in May and June 2020. There was such uncertainty there. I found there's a little bit of sense that the tenants have been through the worst of this. They're coming back in. You should be able to generate revenue or whatever they do to cover the rent again. So I've sensed a little less. There's been fewer office workouts, so to speak, lately than there have been.
That's very helpful. And I did have a client that used that very transparent financial condition, including bringing in bankruptcy counsel, and was able to successfully terms of it. Nicole, so before we move on to kind of, I want to get back to kind of new leases and the kind of provisions that you want to have in there and strategies for gaining leverage and whatnot. But before we move off of that, with respect to existing leases and an association that is looking to make a change, reduce their footprint, reduce their rent, get some short-term rent abatement, all of the above or some other changes, are there any other tips, tools, the trade strategies, techniques that we haven't talked about already that you think the folks should know about?
It really, so I think, looking in, talking with your real estate team, your attorney, and understanding and explaining what really drives your organization, what the strong points are of it. So what do you have to offer? What is your best leverage? And is that that you're funded and you have this strong backing? Is that you have potential growth opportunity? Whatever it is, use those data points to your benefit to, again, create a strong story to the landlord, whether it's the current landlord or prospective landlord, as to what your organization stands for, what it means, and what's behind it. And I'll just add to that. I mean, in terms of the market, we are seeing signs of life and re-entry and market, the market itself picking up. But with that being said, to Adam's point, we are seeing the best and highest concessions from a tenant's perspective that we've ever seen. And it's a matter of how long that these are going to last for. But it's tremendous in terms of how much money landlords are giving to tenants to build out their space. With that, in the past, those tenant improvements have been that you can use them in only certain ways and for specific uses. We're now seeing in updates where you can actually use them for a variety of uses, and it's not as particular as to what that could look like. So just, the name of the game, and I think what we're seeing and the bottom line is there's a lot of flexibility here and a lot to be negotiated. So it's just meeting with your team and coming up with a strong story and a strong solution for what that could look like moving forward.
Following on that, so with respect to subleasing, you talked a little bit about this earlier. You talked about the types of provisions you want to negotiate in a new lease to give you more flexibility on subleasing. So you're not limited in the pool of sublease candidates, you're not walled off from existing tenants in the building or existing, prospects that the landlord's talking to or anything like that. But let's say you don't have any of those flexible provisions and it's pretty strict, but the association really needs to reduce its footprint by, 40%. Are you seeing any success if an organization can go out there and find a subtenant, maybe one who's willing to do it because it's going to be a great deal, right? The association's going to take a haircut and they're maybe not going to cover their rent in full for that 40%. maybe it only covers, I don't know, certain 80% of it, but still it's a great deal for the subtenant. Are you seeing success in situations like that with the tenant being able to negotiate with a landlord and say, look, I know it may not technically be allowed by the lease, but we have this subtenant, an existing tenant of yours in the building. They're actually looking to grow a little bit, take more space. Would you allow us to do that? Things like that. Are you seeing that flexibility on the part of landlords extend to that sort of thing as well?
It really depends on the landlord, depends on the tenant and the opportunity, but we ourselves have advocated and had provisions struck that weren't as conducive, or if we had an organization that we really wanted to sublease to, but it didn't exactly fit the criteria, going to the landlord, talking it through and being able to negotiate that could move forward. But again, it's very much on I think on a case-by-case basis, because to Adam's point, there's a lot that landlords just aren't willing to do and want to stand their ground on certain things and don't have to give. So, making the case for why it makes sense. In terms of subleasing too, you really want a space that enters the market with a splash. So you need to price it right. It needs to be move-in ready, ideally. The furniture needs to be there. You need to be able to walk through the space and it be staged and clean and crisp and ready to go, because you have that one chance to make the impression. And, I would say rewind 9 months ago when, we were still in the beginning of the pandemic. Certainly it was a lot trickier because a lot of people were at home and groups weren't looking to go into subleases. But I'd say fast forward to now with the vaccine distribution very much underway, with a lot of tenants returning to the office, we're seeing a real uptick in activity. And certainly I would say it's a good time if you're looking to evaluate and figure out if you want to put your space on the market. There's a lot more activity now than there was 6 or 9 months ago. So it's certainly a good time to evaluate that for sure.
Hey, Jeff, can I add on to that for a second?
Yep.
So on the subleasing, I agree with what Nicole said, but even a relatively poorly negotiated lease from a tenant perspective usually says that the landlord at least has to be reasonable. The problem is, what Nicole's alluding to, is there's sometimes carve-outs to that reasonableness for competing tenants or tenants landlords have been talking to for similar space. But if you're stuck with a bad lease on the sublease provision, or if just taking your space to the sublease market isn't the right move for you, landlords historically have been pretty flexible, and your existing lease may give you this flexibility with something that's short of a sublease, which is basically what we call just like a space occupancy agreement, particularly for nonprofits or associations. If you've got an organization with a similar mission and you just want to share overhead and they don't need signage and you're not putting up walls and it's not really a branding exercise, we always negotiate for tenants on the front end and leases the right to do something short of a sublease, where it's really just an organization where the landlord doesn't have to worry about walls going up and branding and treating them like a subtenant, where to the naked eye, it's really one group basically sharing a conference room. And if you're a nonprofit or association and you're bleeding revenue and there's someone that may be in that category, your lease may give you that flexibility without, even if it prohibits sublease, it doesn't always prohibit short-term licenses. And landlords, they're almost always, even if the lease doesn't expressly permit that, fine with that, because to the naked eye, it's not really a change, and you're not fishing in the same pond with the groups that they're talking to sign really long-term deals. For what I'm talking about with these space sharing occupancy arrangements, it's usually short-term. The other organization often doesn't share in the expenses. They just pay a flat number and maybe their own phone bill. They get to use the conference room. And it's a good way to pick up some revenue without necessarily having to involve the landlords.
Right.
That's a good point, Adam. And I know you and I have worked on a number of leases, and getting that licensing provision in there is really important and can be really helpful. And that came about, I want to say, a number of years ago when co-working was on the rise. And so that provision is to kind of help and combat co-working, because if an organization could quickly go into a co-working environment with a license, why couldn't that same organization quickly go into association or nonprofit space with a similar type of licensing agreement? So that's a great point.
And I would add to that, there are, at least in the DC area, actually I know in some other cities as well, like New York and I believe San Francisco and Chicago. There are a number of buildings that are, it's usually for like associations in a given space, like higher ed, or you name it, healthcare.
Right.
There's a number of, and sometimes just a bunch of different tenants that contract with the landlord, for lease space, but they want to be in that space. But a lot of times it's a lot of smaller groups that are doing sublease arrangements and things like that, more than just the short term, but on the longer term. And one of the things that I predicted this would happen at the start of the pandemic, just like it happened in the 08 recession. And that is, when we have tough economic times like this, there tend to be a lot of mergers in the association space. And I use the term merger broadly to include all types of combinations between organizations. And I'm seeing that now. I'm working on several of them right now. And what that often means is one association may actually need to grow its space to accommodate some extra staff that it's going to bring on as a result of that. So that is one dynamic that is going on. That is a positive effect on associations that may be looking to grow their space. And another kind of takeaway I'm getting from you guys is that obviously the lease terms very much matter, and ultimately it's a contract that you're bound by. That in these times when tenants do have some real leverage, that don't just look at your lease and say, well, it doesn't allow us to do this, so we're done. What you're both suggesting is figure out, I do this all the time in my practice and all the other areas of law, figure out what your leverage is and then try to utilize it to get the landlord to make a change. Leases can be amended, exceptions can be made, things like that. And if it's in the landlord's best interest overall, they will be willing to do that. We have a question, I give this one to Adam first, but it's really for both of you. So this is let's focus on new leases. Whether it's an amendment to an existing lease, or you're going to a new building, like the example that Nicole gave. The new landlord wants you there so badly that they're going to let you live there the first 2 years rent free, so you can get out, basically be able to still pay your old lease, go into the new building, but then have a long-term lease beyond that you'd be paying for. But in any event, when you're negotiating a new lease, my friend Brian Summers asked, can you provide a probability of how these terms will be accepted, as I expect some are going to be easier than others to get into a new lease? So, and it's classic negotiation strategy that all three of us always do a ton of, and that is, you're not going to get everything you want, right? You're going to, you got to figure out what's most important to you. You're going to give on some, you're going to get on others. All depends, of course, on some of the other things, like how valuable a tenant are you to the landlord, how much you're paying compared to market rates, all that other good stuff. But any kind of negotiating, I'm going to kind of rework Brian's question a little bit. Any kind of negotiating tips or strategies to try to get the most favorable provisions into these new leases? I know it's a very big, broad, high-level question, but I guess what I'm looking for is just general negotiation tips when you're negotiating new leases.
Yeah, an easy one, but it's an important one, is when you're at the stage with your broker where you're selecting the space, and it's the honeymoon stage, and the landlord really wants you, and they haven't produced the lease, but you're exchanging what's known as the letter of intent, which basically says, here's your rent and here's your term. Make all your substantive asks right then, because that's when you've got the most leverage, before the landlord has hired his lawyer and produced the document. So in that letter of intent, if you think you merit a cap on controllable operating expenses, say of 5%, and we can talk more about what that means later, you got to put in your letter of intent. If you want a termination right, which Nicole is talking about later, which on a 10-year lease, maybe you can terminate after year 5 if you pay the landlord its unamortized transaction costs. You got to get in your letter of intent. So that's a temporal point, Jeff. It's really important. If you make these asks after you hire me, and you hire the lawyer, it's kind of too late on some of this stuff. It's not too late to get your assignment sublease provision right, negotiate some exclusions, but for the high level, really important stuff, contraction right, which Nicole mentioned, the scope of your renewal right, do it at the letter of intent stage. That's your maximum leverage point. Because a lot of times the landlord's broker will agree to stuff without even necessarily checking with his landlord client, and it kind of can slip through the cracks. I've seen it happen a lot, basically. So even though that sounds basic, That's what comes to mind for me immediately.
It's a great suggestion, and I use that all of the time in other settings, like with associations that are doing an RFP for a meeting, a conference meeting. Put the key provisions that you're going to insist on in the RFP, so that any hotel, convention center, CVB, whoever might do a proposal to want to host your meeting, they're going to be bound by those conditions. They're going to know what they are. You have maximum leverage at that point. I'd say the same thing to associations when they're negotiating like an employment contract with a new CEO. Say, don't say to the candidate, you're our first top choice, and then get into the contract negotiations. Before you even get to that point, agree on the key terms in some sort of a term sheet, equivalent to a letter of intent that you're talking about. That's when you have the leverage. Once you tell the candidate you're their top choice, then you lose a lot of leverage. So I think it's a great suggestion. It sounds simple, but it's a really important concept. And
that's why, often, you haven't hired the lawyer yet, you're not hiring legal. That's why it's so important to have someone like Nicole, if you're in a different market, where she's not working, a comparable broker that's going to help you negotiate the letter of intent, not just the rent, but all these other points. Like that's a key component of this, because you're all now on signing leases every day. They know the marketplace. They know kind of what to ask for, who your tenant broker is. It's a real important selection, not just to get the best rent, but to get all these other terms up front as well.
And Jeff, I would just add 2 points. Certainly as a real estate broker and also looking to the attorney, there's certain provisions now that we're collectively, accumulating how many landlords have agreed to this provision. And so having that snowball to say, okay, now we have this percentage or this number of landlords who have agreed to this provision, to Adam's point, getting that into the LOI to then move it forward. And that could be some of the pandemic protection, some of the base year protection, which we can get into, but making sure that we've now set the standard as to what we're seeing in other leases and putting that into the LOI. The other thing I will note is that, again, things are negotiable and customizable. So if an organization says to me, parking, I have a real issue with parking. I actually need more parking than typically what's allotted, or I need some free parking. You know what? Now's the time to ask for those things. And if there are a few key provisions that you feel just really are important to your organization and that you really need them, let's talk about them and let's get that agreed to. Back to Adam's point up front, let's put it in the LOI, because now's the time to ask for those things. Landlords have been known, we just had something, an organization recently, a small association, but they wanted signage. And because of the name and who they were and the ask, we actually ended up getting signage on the building for a pretty small user. So you never know until you ask.
Well, it's also a good reminder of the importance of working with both a real estate broker and a real estate attorney that really understands these transactions, that does a lot of transactions with associations and other nonprofits, that really knows the norms, the best practices, what concessions are making. I know in my practice, it makes a huge difference when you're negotiating on behalf of associations with the same vendors all the time. You get a sense as to, how far you can push, what you can get, use that as leverage. Same thing with you guys. And it's a great point. Let me ask you more of since I know the two of you guys work together a lot, how would you just basically describe the role of each one of you in a typical kind of leasing transaction for an association? Because I know a lot of people get confused about that. I've even had that in a question. Most realize that they need a broker to help them find space, right? Most associations, when it comes to commercial real estate space, are not going to typically go out and try to find it on their own. But a lot of times they don't understand the importance of the real estate attorney. And it's one of those few areas of law that I believe is so specialized that we won't touch real estate leases because they're too nuanced. Like, I don't know the norms and the best practices. That's what I bring in someone like Adam to work with my clients, because he really does know those things. I wouldn't know what I don't know in terms of what's missing or what to suggest or push back on. But how would you describe, Nicole, kind of where I know where your role starts, but kind of where do you bring in Adam, and how does that transition occur?
Sure. So I see it very much as looking at the importance of the business and the business structure and business terms, and then bringing in legal to then make sure everything that we've talked about and negotiated and all of our intents are then documented and fully negotiated, so that when we get to the LOI and then ultimately to the lease, that's all in there, and we have it and we're protected. So in terms of where we bring Adam in, certainly, you know, so let's say we've gone through the process, we've evaluated the organization's needs, we've determined what their square footage they're looking for, what buildings, we've toured the market, we've shortlisted buildings. Now we're looking at, and we've narrowed it down, we have one particular we're looking at. We're heading towards now to an LOI. When that's at that time, if the organization doesn't already, I highly recommend that they bring in Adam or someone like Adam to review the LOI, see if there's anything else from a legal perspective that they think needs to be in there before we submit it and sign it. An LOI is non-binding, but at the same time, it is a good faith effort in terms of moving forward. So it's something that we do want to get right. And so bringing in Adam at that time, review that, but then certainly leaning on Adam and him and I working together on the lease to understand, okay, well, here's what they said, here was the intent, or here's the business use and purpose of it. Now, can you put that into the document and from a legal perspective, and let's talk it through the pros and cons and what do we need to protect ourselves. And so that's where there's a lot of collaboration going on from that LOI to the lease and beyond. And then certainly on a day-to-day, if something comes up from a tenant's perspective, or if they want to change something with their space or current lease as well.
But let me ask you one follow-up. That's incredibly helpful. In terms of the negotiation itself, right? You're doing the initial negotiation, you get the LOI in place, you bring in Adam. You know, usually I guess the initial lease is going to be proposed by the landlord. You know, Adam's going to mark it up. And who typically, I know every situation can be a little bit different, but who typically in your average situation is going to be negotiating with the landlord or the landlord's representative? Is it going to be you, Nicole, or Adam? Are you going to both be doing it? Is it a lawyer-to-lawyer thing typically, a broker-to-broker thing? How does that usually work?
So we work jointly, and I feel very strongly about that. So we're coming in, you know, and I'm coming in from the business perspective again. Adam's coming in from the legal perspective to make sure there's no stone unturned. What we pride ourselves is making sure that we are involved, because what you don't want to have happen is that you send it off and you pass it off to legal, and there was something that was discussed early on that never gets documented that legal didn't know was the case. And so the tenant goes back and says, remember when they said such and such, and then you look and it's not in the lease. So in order to make it cohesive, and I think frankly to look at it from the most holistic approach, is to have the business and the legal working together from the LOI all the way to the end. So Adam and I are on calls together in terms of the lease negotiations. And certainly when it's a business point, I'm leading the charge. And when it's a legal point, it's Adam that's talking it through.
So that was my real question on the communication with the landlord or landlord's representative. It sounds like you generally are doing things jointly. You know, and obviously it might vary depending on the issue. And it's not like Adam has to be on every call or you have to be on every call. And there might be some technical legal points that Adam's going to speak to the other landlord's counsel on one-on-one. Adam, anything to add on the overall issue of kind of lawyer to broker relationship and working model?
Absolutely. So one thing Nicole didn't say, but I think this is really important, because what she does and what her group does is when the LOI is done, they bring in the lawyer, but they're not handing it off to the lawyer where they're out of the process. Get a commitment from your tenant broker that they are going to read the lease. It's amazing how many of them don't do that. They strike the deal with the letter of intent and they think that they're done and they're just waiting for the lease to be signed and collect their commission. For the points Nicole was raising, you gotta have that continuity or something's gonna get missed. Look, I'm biased. I think you should always hire an experienced real estate lawyer, but obviously I have a bias. I mean, in any organization, the number one cost is employee cost, and number two cost is rent, right? And the lawyer's not negotiating the rent for you. Nicole does that, and that's done at the letter of intent stage. But the lawyer plays a pivotal role in the additional rent provisions and how the operating expenses work, that you have an audit right with respect to those, that you're not being overcharged for other things. There are other financial things that could crop up during the term of the lease that having an experienced lawyer who knows that marketplace, right? I mean, what you really want, the reason Nicole and I work so well together in comparable relationship is her and I both know this market really well. My firm represents landlords, we represent tenants. We've done a lot of deal with Nicole. We've seen what's happening, kind of comparable buildings around town. So I know what's market for this size tenant in this marketplace to ask for, and that's really what you're paying for.
Excellent. All right, let's move on to a couple other topics. So, Nicole, you referenced earlier the fact that you are seeing tenants having more success recently in being able to get concessions for build outs and other things like that that don't have nearly as many restrictions as they used to be. Certainly, while we still remain in the COVID era and likely will for some time in terms of even once we get to a higher vaccination level, the need to have appropriate social distancing and other accommodations in the workplace. And I know some of our clients have already done build outs of their workplace because while a lot of people may think that associations have worked kind of seamlessly remotely for the last year and that's going to continue and there's no issue, there are many associations and many CEOs that I talk to that are dying to get their workforce back. They don't feel that they're working as effectively and perhaps as much and as efficiently as they did when they were in the office. And there is a big push by a lot of employers in the association space to get more employees back to the office, but there are going to have to be accommodations made, whether it's spacing, whether it's kind of dividers between cubicles. As you well know, in recent years in DC and in other cities, there's been this move in the association world to getting away from individualized offices and getting to these open floor plans and whatnot, which is pretty much a nightmare from a COVID perspective, but the worst thing that could happen. But that's what so many of the build outs are. So tell us what you're seeing tenants right now doing, both to get their workplaces kind of prepared for the return of the workforce to the office, but also in terms of other things like wellness and whatnot. There seems to be a higher appreciation amongst association and nonprofit employers now about, when we do bring people back, we want to make sure it's a good, healthy space that we have, employees feel good about it. So give us some ideas of some of the things that you're seeing some associations do in these areas.
Sure. I think it's the associations themselves, and it's also the building owners that are also contributing. So I'll answer the question kind of twofold in terms of, the encouraging signs that we've seen, and certainly wellness has always been important, but it's really brought it to the forefront in terms of employees and what employers are doing to move that forward and make employees comfortable and also have that wellness component and make that of more importance. So what we're seeing, a lot of the landlords during this time while tenants were away have upgraded their filtration systems. So we're seeing the latest and greatest in terms of that. So MERV 14 is the filter that we're seeing. So if you're in a newer building or a building that can handle that type of filter, that's really what you want. And so there's also, if your building can't handle that, it's also bringing in as much fresh air as possible. So air and air quality is a real component. And so from the tenant's perspective, talking with the landlord, and we do this all the time for the tenants on their behalf, but understanding from the landlord, what have the landlords done to the building, to the systems to upgrade while tenants have been away. There's a lot of now much more touchless features. And there's just a lot more in terms of understanding COVID and just cleanliness and overall comfort of buildings and spaces in general. In terms of what tenants are doing, it really runs the gamut from everyone still staying home because organizations think they may be headed in the direction of people being fully vaccinated before they come back to the office. Now, that remains to be seen. I know I saw a news article with Davis Wright was one of the first law firms to come out and say that they are going to, in fact, require their attorneys to come back and their employees fully vaccinated in order to return to the office and to the workforce. So I think that's still something that associations and nonprofits are kicking around, and we'll see, where that goes. But in terms of the space itself, it's going through the space. It's looking to de-densify certain areas and understanding whether you're pulling apart, to your point, Jeff, about having open spaces. Now they want them less open. They want less people in those open areas. So we have a full team of workplace strategists that can go through with our clients and look at the association, the nonprofits, look at their space, identify kind of hot spots where there are going to be issues because they're not going to be 6 feet apart. There's just too much going on in that area and a lot of it's looking at their plan and figuring out how to configure the plan or work with the plan that they have and just work it in a different way. So that's very much what the tenant is looking at. I've also seen, creatively, which I think is smart, associations and nonprofits, when they do bring their employees back to the office, they're looking at it as a welcome back. Because your employee has been gone for over a year and takes, 30 to 60 days to form a habit. So new habits have been created along the way. And so people are very much used to working from their homes, to your point, not always effectively and not always well, but that's just the way it is. So when those employees come back, what does that welcome look like? What's the welcome package? What's the message to bring them back and to make the space a space you want to come back to and the employees want to come back to as well?
Very helpful. And one point that probably some people listening, watching, a question popped into their mind, and I know we get the question all of the time, which is from a legal perspective, can an association employer mandate that its employees be vaccinated before they come back to the office or before they do other things, go to association conferences, travel on behalf of the association? And while the EEOC, the Equal Employment Opportunity Commission, is likely going to be coming out with additional guidance beyond what they issued last year, the current guidance and the current state of the law is basically, in short, that an employer can impose such a requirement. However, it has to make exceptions for those that have a medical condition or a disability that prevents them or puts them at high risk of getting a vaccine, and for someone who has a sincerely held religious belief about getting a vaccine. And the latter issue I actually just dealt with last week on behalf of a client that has an employee in that situation. So you have to make accommodations for those people. For most association positions, that accommodation, will often be the ability of that person to continue to work remotely. That's not always the case. Not every position lends itself to that. Most tend to, but not all do. But that's the basic legal construct at play. That being said, I will say that what I've heard from most by far of the association CEOs and nonprofit CEOs who have made a decision on this so far is that they are not going to require mandatory inoculations.
Right.
One other wrinkle, there is this lawyers talk about this, the employment lawyers in particular, about the fact that the current 3 vaccines that are authorized in the US are under an emergency use authorization. They're not subject to formal FDA approval. That formal approval is expected to come later. But there's a line of thinking in the law that if it's an emergency use authorization, that somehow has to be voluntary for the employee, and that you couldn't mandate it. That's kind of an open question that has not been squarely resolved from a legal perspective. Adam, what are some kind of in new leases that you're working on now, coming through hopefully the worst of COVID, not through it yet, but hopefully through the worst of it? What sort of changes or new provisions or other things are you seeing as a result of this COVID experience?
Okay. Yeah, good question. So if you are doing a new lease and you are in charge of the construction, you're the one who's going to go hire the GC and the architect. The usual construct when that's the case is there's a hard date when your rent's going to start. You're kind of taking the permitting risk and the risk that your contractor is slow. It's pretty much baked into the cake now that if your construction project is delayed because of a COVID type situation, that those dates will toll, T-O-L-L. They'll be pushed out if your construction process is slowed down. That wasn't always the case. We had this long debate in the industry about what is and isn't force majeure, but it's become accepted now that while tenants generally take force majeure risks, slow permitting office, bad contractor, they're not going to take the risk that on something like COVID, since it really affects the whole industry generally. So that's one thing. If you're doing a new lease, you're in charge of construction, make sure that you get those dates pushed out in the event you're delayed for a COVID type situation. If the landlord's doing the build out, you're pretty much going to be stuck with rent starting when the landlord delivers it to you substantially complete with whatever contractual abatement you've negotiated. We're not really seeing to a great degree that your rent will abate in year 2 or 3 if COVID comes back. Landlords or something similar, landlords really aren't as accommodating on that. When the pandemic first hit, there was some landlords willing to do that just to get leases signed up. But I think that they're more sympathetic to that again on retail than office. So, but if you're doing a new lease, a critical thing to understand now, particularly if you're doing what we call a full service lease, is what exactly your base year is going to look like from a cost perspective. Most office leases are what we call full service leases. You pay your base rent, and then you only pay your proportionate share of increases in the landlord's expenses above what we call a base year. So let's say you were signing a new lease right now and you're going to move in at the end of this year, early 2022. You're going to probably have a 2022 base year for your expenses. Say they're going to be $30 a foot. And then in 2023, they're $32 a foot. You pay your share of that increase. So it's really important now that the base year be grossed up, as we call it in the industry, to reflect if the building was fully occupied. Because right now, landlords' costs to operate buildings are way down, which is a good thing if you're an existing tenant. You're getting your reconciliation of operating expenses, and their estimates were probably high because their cleaning bills lower HVAC. But if you're a new tenant, you don't want that base year to be artificially low because not everybody's in the building. And most leases have what we call a gross up provision. The base year for expenses reflects a 95% leased up building. What you need to do is negotiate that so it reflects a 95% occupied building. So it's if the landlord was running a full expense load, so that in subsequent years, your base year is high enough so that when all the expenses go back up, normal expenses 2-3 years from now, you're not paying on too high of a delta. So right now for new leases, the operating expense provisions are a critical thing to look at. And it's a great time, throw the kitchen sink at them, ask for a cap on controllable operating expenses of 4 or 5% a year. Landlords hate to give it, but they will give it to you if you push them for it. Now what that basically means is other than real estate taxes and insurance and things that landlords have no control over, for their choice of who the property manager is and who does the lawn maintenance and the cleaning, that they agree that increases in those kinds of controllable costs are capped at a certain percentage as it relates to your expenses. I think those are my two ones to really chime in on. I like Nicole should weigh into it because this is right in her wheelhouse also.
Yeah. Terrific, Nicole, please do. And also, well, why don't you weigh in and then I have a follow-up question for you.
I think Adam certainly hit the nail on the head in terms of those two, and those are hot points as well. I think in terms of what I call kind of pandemic protection, to Adam's point, we are seeing where some landlords, fast forward in terms of new leases, will say if there is a pandemic type event again in the future, that there could be a delayed type rent or a delayed structure. So to Adam's point, he had mentioned that landlords are less likely, some did in the earlier stages of the pandemic, give and say that they would perhaps do some free rent. What we have negotiated is a delayed rent structure. So in case organizations get in a pinch, there is a way that they could do that and pay at a later point in time, but it is still due. So it's helpful, but it certainly doesn't, mitigate or remove those costs altogether. But that is something that we've seen more and seen because of the pandemic for sure. The base year, one interesting and kind of anecdotal thing I'll leave you all with is that we're seeing more pet provisions. So in terms of wellness. Yes. So prior to COVID, pet provisions were typically not in institutional buildings and not with institutional landlords. Maybe there would be a one-off landlord where you could bring in a pet or a few pets. And I know, this was big a few years ago with tech organizations, but it's seen its way too in terms of associations and nonprofits. And again, another form of wellness. But I'd say, interestingly enough, these are creeping into institutional landlords and to leases. So it's evolving, it's new, and we'll see how it goes and where it goes. But you may be able to bring your pet into the office, or some of your employees may be able to bring them in if they're interested. So just food for thought.
Well, I was thinking that earlier when we were talking about what people have gotten used to working from home, and it's one of the things we all see it on our Zoom calls with clients and others that you know, the dog running across the screen or in the background. And that is, you know, there's silver linings to everything, including the pandemic. And that's one of the things that a lot of people have enjoyed, is being able to be with their pets while they work during the day. And a lot of people would like to continue that. And we've seen that already with certain, not as much on the association side, on kind of more charitable philanthropic nonprofits. But have you seen any associations or nonprofits have success getting an amendment to an existing lease to allow that? Because, you know, generally, I would assume all of these leases, the default is, you know, no pets except for service animals in the office. Are you seeing any having success, not just in new leases, but modify existing leases?
It's in process, so I'll let you know the answer in a number of weeks, but that is being talked about and kicked around. But because of all of it being so new, nothing's been finalized. Certainly easier, to your point, in new leases, but looking to incorporate that and give that as a component of existing leases when it's being restructured and renegotiated as well.
What I'd say to that, Jeff, you're not going to go to your landlord and say, hey, I want to change my lease to allow pets and do an amendment just for that purpose. But if you're otherwise amending the lease, throw it in there. And on that point, frankly, it used to be that there was this kind of gentleman's agreement that if you were redoing the lease and amendment, you wouldn't look at a lot of the boilerplate that was negotiated 5-6 years ago. That's out the window right now. If you've got a bite at the apple where you're redoing the lease for whatever reason, pay somebody to read the entire lease and see what else could be potentially improved. Because that's your chance to do it. And on the other thing at pets, I told myself I had to get this in today. Your gym in your office building is probably not going to be opening anytime soon. I've had landlords call me terrified of the CDC guidance that if they were going to reopen their fitness centers, they'd have to have someone in there to wipe it down after every user. So I think we're also going to be working out at home for the foreseeable future.
Yeah, I'm not surprised.
Your pet in.
Adam, to that point, we've already seen some landlords pivot and offer virtual workouts. And so be able to go onto their platform, and tenants are able to log in and do virtual workouts, but certainly not in the gym itself.
Interesting. So the landlord is subscribing to some, you know, service, Peloton or something else where and they get access, they get a license for all their employees to use it. That's interesting.
That's right.
To your point about Adam, about kind of the boilerplate stuff, you know, one of the things that I've seen, especially my colleague and I over the last year, what a lot of associations always viewed as boilerplate in the past was something called the force majeure provision in hotel and convention contracts, became the most important provision for so many associations over the last year, and was invaluable in getting so many associations out of thousands and thousands, sometimes millions of dollars in cancellation penalties. What Nicole was talking about is essentially kind of a modified force majeure provision in future leases for a you know, COVID or other, you know, similar unexpected type catastrophe, not to let them out of the lease completely, but to give some, you know, short-term rent abatement and things like that. I think that's really interesting. All right, I'm going to just throw it open to each of you for any final kind of closing thoughts. I'll start with you, Adam, and then we'll wrap it up, unless anyone has any other questions from the audience. Any other closing tips, suggestions, overall thoughts, guidance for the group today?
No, I mean, I think we've covered all the food groups we wanted to cover. I mean, to pick up on something Nicole said earlier in the seminar, never hurts to ask, right? It's a good time to be greedy if you've got a chance to be in front of a landlord, particularly on a new deal, and be greedy. And frankly, on the flip side of that, if you go to, the landlords really appreciate, if you need to go to them for some relief, the tenants who put some thought into it, provide the financial backup, and have a well thought out presentation. So if you need to do that, just put your legwork in on the front end, because they're getting requests kind of from everyone, and a lot of people are lazy about it and don't provide the backup if they need the deferment or the abatement. So landlords do appreciate the effort that's put in on the front end. And if you're going to make a commitment to the building beyond as a quid pro quo, you'll at least get an audience.
Okay, before we get to you for the final overall closing, Nicole, we have a question that says, if a landlord is not opening their gym, is the landlord still responsible to provide showers in the building for commuters if the building is LEED rated? I don't know what the LEED ratings have to do with showers in the building. I don't know if that's one of the requirements to get LEED rated or not, to encourage, you know, people like to ride bikes or whatnot as opposed to driving. Maybe it is or it isn't. I don't know if any of you know, either of you know the answer to that. And obviously everything's negotiable, but is there any LEED requirement to offer showers in a building? And I guess the question is, if their gym is shut down, do they still have to keep the showers open for people who are jogging or riding the bike into the office or something?
Nicole, you want me to take that, or you want to?
Yeah, I'd like to hear from a legal perspective, because I know right now they're closed, and so I don't know at what point and what your perspective is on that.
Yeah, I don't think so. I think the short answer is no. I don't think you're going to be able to go to the landlord and say, even though you were either required by municipal ordinance or it was just prudent management to close the gym, that you're required to provide access to the showers, unless there's some specific contractual provision or some other issue. The LEED rating issue, that they've had to design the building a particular way to achieve that rating, but it's unusual that if you're in a force majeure pandemic situation, I don't think a landlord's going to lose its LEED rating if it doesn't have its showers open.
Yeah,
my instincts tell me no.
That was my general thinking as well. And then one more specific question. So we know that I know that a lot of landlords, you guys know too, have been doing some things during the pandemic in terms of air quality, filtration, fresh air, things like that. You know, perhaps planning for enhanced sanitation protocols and things like that upon reopening. But for some of the other things, well, even if a landlord has not done those things and the tenants are demanding them, and for other things that are maybe more within the particular office space of the tenant, are you seeing, Nicole, or either of you, any luck for tenants getting the landlords to pay for some of these things? I mean, certainly air filtration and things like that's got to be a landlord expense. It's not something the tenant's going to do. But making structural changes in the build out, for instance, of the layout of the space, putting dividers between cubicles, things like that, is that always going to be on the tenant to pay for that? Or are you seeing in some cases landlords being willing to share or assume some of those costs?
So it goes back to restructuring and restructuring the deal as a whole. And so from the building's perspective, yes, the landlords are typically making those updates because they want to keep their current tenants happy. But for them, they also want to make sure that any new tenants coming into the building, that they're measuring up with the others. So landlords are typically taking care of those building structures. In terms of the space itself, if the tenant wants something specifically, then they should work with us in order to negotiate to get that, but get the landlord to pay for it through a restructured lease and lease negotiation. We're seeing UV lighting being put in. We're seeing additional filtration systems put into the tenant space itself. We're seeing dividers, seeing different furniture solutions that would help with COVID or you know, wellness in general.
Yeah, I mean, I was just going to add on to, if you're going to the landlord and you're extending term, as Nicole said, otherwise restructuring your lease, you'll get an allowance for some alterations, which is really what you're describing. But if you just want to throw up a wall to make your space more efficient in the middle of your lease term and you're not extending, the landlord's not going to pay for that. That's going to be on.
Okay, well, so that's an important takeaway here, that even though, you know, the CDC recommends these things and OSHA recommends these things, doesn't mean that the landlord, that you can just go to them and say, hey, look, see the CDC guidance, see the OSHA guidance that says you should be doing this. We want you to go ahead and pay for all this. That doesn't by itself just ask them to do it unless something is legally mandated. And this is something I get into all the time with clients and in webinars and whatnot. You know, there's things, particularly at the state and local level, that are legally mandated. And some of these do relate to office spaces. And we're going to see more of that in the future, certain mandates from state and city and county governments. You know, if there's mandates on a landlord, obviously they have to comply. But at least to date, all of the federal guidance has been advisory in nature, not mandatory. And so that's a critical distinction when you're talking about who's going to be forced to pay for those.
Well, and even there, Jeff, what you're talking about there, those advisory things, those really relate to the common areas, right? The lobby, the gym, structural, the HVAC. The four walls of the premises, almost every lease provides that legal compliance with respect to what's inside the premises is on the tenant. I mean, it's one, maybe not how the air reaches and some of the base building systems, but with respect to the four walls, partitions and all that, that's always on the tenant.
Yeah. All right, Nicole, any closing thoughts, and then we're going to wrap this up.
Yeah, I have one more piece of advice I think would be helpful, and we didn't touch on it today, is there have been a number of associations and nonprofits, whether in cities where they're opening offices or if they were just smaller footprints in general, that were looking to co-working spaces. And co-working's taken quite a hit during the pandemic, and there was speculation prior to COVID how they would do, and we've seen a lot of them that haven't made it out in post or heading into post-COVID. So what I would recommend is, and what's been encouraging, landlords have now been building we call pre-built or speculative suites, and they now rival what an association or nonprofit would have gotten in a co-working space. So that it's all the way, fully built out, furniture could be included. The good news now is that with landlords and us putting pressure on landlords for more flexibility, those typical suites that the landlord had built out in the past, you might have had to have a 3 or 5 or 7 year commitment. That's why going to a WeWork or Car Workplaces or one of the others was more attractive, because you could do it for a couple months and then be on your way. Well, the good news is with those pre-builts now, landlords are offering shorter terms. And so you can get into your own space. It's certainly, COVID friendly. It's friendlier than having to go through to a co-working environment where there's a lot of people going in and out. And pricing wise, interestingly enough, typically in co-working on a per square foot is about double the price of a per square foot when you go to a direct deal, but it's factoring in that flexibility. So I think it's, again, talking with us to understand how many people, how flexible do you want to be? But I would certainly suggest giving a really hard look to these landlord pre-built suites, because they're sitting there ready to go, and you can get some pretty phenomenal deals and real flexible terms.
That's great to know, especially if I know there's a lot of associations that are, say, looking to get rid of their current big office footprint, but still want to have some opportunity to have staff rotate, come to the office, have all the staff come in for occasional meetings and things like that. And that's a great cost-effective option. But it's not just landlords that are offering that. I mean, I've seen it from actually some larger associations that are doing it on a sublease basis. Maybe
Right.
they didn't go into with the intention of that. Maybe they just took too much space and realized they want to turn it into like a subleasable space. Often with smaller associations in their same field. There's a lot of these special associations that kind of maybe fall under the umbrella of a bigger one. And even in some cases, offering up other services to go along with the space. And I'm not talking about just like telephone service and Wi-Fi and internet service, but things like accounting services and other things, since they have it almost becoming like an association management company in some ways, perhaps without the staff portion of it, but all sorts of creative, flexible models that have existed pre-COVID. But I think you're right, we're probably going to see more of this going forward. I want to thank both of you for a terrific job. This was, when we put this together, I thought it was going to be a really helpful, informative program based on all the questions that I've been getting. But to me, it was even far more than that. You guys hit it out of the park. I really appreciate your time and your thoughtfulness in today's program. Thanks to Mark and the Association Societies Alliance for hosting this program and enabling us to talk with you guys today. We appreciate it, and hope you guys enjoy the rest of your day. Thank you very much.
Thank you.
Thank you. Thanks for having us.